Alleged crime boss Vusimuzi Cat Matlala's testimony before the Madlanga Commission has been postponed to the 1st of September. Matlala asked for additional time before he testifies because he's due to start his criminal trial next Monday. His legal team urged that Matlala needs to be allowed to have a fair trial, and allowing him to proceed with testimony at the commission would have stood in the way of that. However, the commissioners were not in agreement with Matlala's submission but granted him the postponement. His lawyer, Annelien van der Heever, argued that Matlala wants to obtain the investigative directorate against corruption material that led to the collapse of his plea negotiation with the state before giving evidence at the commission. However, the commissioners maintained that the plea negotiations have nothing to do with the commissioner's work. Justice Madlanga announced the ruling of Matlala's postponement application. Mr. Matlala must file his statement not later than the 29th of July 2026. The hearing of his testimony is postponed to the 1st of September 2026 to continue until the hearing has been finalized. This is the second time his testimony has been postponed.
The issues either at all or as clearly as you have done now. And that is because, for example, the application says the entire commission process must be postponed pending finalization of the criminal process. So it's on that basis that I then ask you, does that mean there are no questions whatsoever that Mr. Matlala could deal with before this commission? Now you have responded and said, no, there are. So there are issues that he can deal with before this commission. Now my next question is, why can't that happen before the criminal process has been finalized?
Because I, as an officer of the court...
At this level, just...
I'm honest with you.
No, let me finish. At this point, focusing only on those, this of course is not a ruling on whether we agree on the Section 35 point. That's something we're still to apply our minds to. But focusing only on the issues that can be carved out of the Section 35 issues. Why can't those be heard or dealt with by this commission before finalization of the criminal process?
So there's three reasons. The first I've already dealt with. I said to you that there was negotiations ongoing, and I need to understand in those negotiations who, what, and where. And without that, I cannot,
Are you talking negotiations relating to the plea deal?
Relating to the plea.
That's history now. I'm asking you about now. I'm asking you about now, please.
It's not history, because it's only if I have regard to those and those are handed over that I can come and say I can answer question A and B but not C and D, because it is clear from what we have been given that is a suspect on these issues. So you cannot answer that question. So that is my first point. I cannot at this point in confidence say to the commission, and I won't permit my client to deal with those until such time as I know what they have negotiated with him, what they've asked him, what he's committed to, what he's not committed to.
Is that not an issue relating to whether there should or shouldn't there be a postponement? And that's not what I'm asking you about.
No, sir,
I'm asking you about the precedence.
Yes,
which of the two processes must precede the other? So I understood you to be referring to the plea deal. In the context of saying, prior to that being finalized, I do not know what to do. I must wait until the end. That's something else altogether.
No, that's not.
It has nothing to do with whether, once the plea deal is dead and buried, must the commission process wait for the criminal process. So the earlier issue, the plea deal, its finalization or even non-finalization has nothing to do with the question I'm putting to you.
It does indeed, Commissioner. If you will permit me just to explain.
All right.
During a plea deal, there is much more than the simple wording in the plea deal that takes place. There's other negotiations that happens between the investigators, the client and the attorney. And during those investigations, there's names that come up, there's information given, etc. And during that negotiations, a person potentially is, and I'm trying to keep it in the abstract, is told, you are a suspect on this matter. Let's say you're a suspect that you connived with General X to do A, B, and C. General X doesn't appear, for instance, in the plea deal. It's discussed there, there's questions made, there's recordings made, but General X appeared in the Regulation 10.6. Now, for me to deal with whether he's a suspect or not, in respect of anything to do with General X, I need to know what was discussed during the plea negotiations. And it's not just somebody sitting there and now we're drafting a 105A.
For what purpose? You are doing that for what purpose?
For purpose of invoking my right to silence on that. I can say,
no,
I've been
then
told...
you don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Matlala is able to deal with before this commission. Now, you are talking about issues that post the plea deal may also fall under the section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside and let's address our minds to those issues about which there is no question. Regarding them being heard by this commission. That is what my focus is on.